Hello and welcome everyone to today's CLE. We're going to give just a couple minutes for people to continue to join us. So please just be patient, hang with us for a moment. Hello to those of you who've just joined. It looks like we still have people joining, so we're just going to give it a moment to let the participants all show themselves, and then we'll get started. So we've given it a couple of minutes. I think the participants sort of slowed down joining, so why don't we get started? My name is T.R. Bynum. I'm managing counsel at Wells Fargo. And I'm going to be your moderator today for today's CLE, which is Time to Pay Up, Not So Fast. Collecting on financial advisors' promissory notes and defending associated claims and counterclaims. I'll be your moderator today. By way of introduction, I work inside Wells Fargo across the enterprise, but my team and I primarily support Wells Wealth Investment Management business unit. Primarily, we work in the competitive space, so that's rating, that's recruiting, and that's also data privacy. And if I could have each member of the panel introduce her or himself, I guess beginning with Sarah Soto.
Hello, everyone. My name is Sarah Soto. I'm a principal with Bressler, Amory & Ross. I'm based in its Miami, Florida office, and I'm a member of its financial institutions litigation and arbitration group, as well as of its employment litigation group.
And Don, why don't you go next?
Yes, good morning. My name is Don Littlefield, and I'm a principal in our Texas offices. We have offices in both Dallas and Houston, and been doing securities related work for, I guess, coming up on 31 years now. And so we're thrilled to be part of the Bressler team down here in this part of the world.
Rima?
Yes. Hi, good morning. I'm Rima Hartman, and I'm a principal in Bressler's Birmingham, Alabama office, where our employment law team is headquartered. And I've been practicing employment law for 27 years.
And last but certainly not least, Justin.
Hi, everyone. I'm Justin. I'm an attorney in the New Jersey office, and I am also part of the Labor and Employment Group.
So one just housekeeping reminder to everyone, to get credit for today's CLE course, there are going to be some codes given out at certain periods in the discussion. You'll need to include those codes on your attendance verification in order to receive credit for today's course. So I just word to the wise, stick it out. We think it'll be fun, and make sure you add those codes when you're submitting your verification. And just to sort of get us started, it's been a long time since I looked at Black's Law Dictionary, but I'm guessing that we all sort of remember that a promissory note is an unconditional promise to pay. some. There are a few circumstances in the broker-dealer world in which you might have a financial advisor execute a promissory note. Usually those are front-end bonuses, what we at Wells Fargo would call transitional bonuses. And then there are back-end bonuses, which we refer to in our nomenclature as performance bonuses, but other firms may refer to them by different names. They all have some similar features. And namely, it's that the firm advances to a financial advisor a lump sum payment of some amount of money, which was otherwise meant to be paid over time, provided that the broker concurrently agrees to repay any amount of that lump sum that she or he would not have been entitled to on some failure of a term or condition of the note. So Sarah, if you could please just walk us through some of the salient features that might constitute an incident of default under a promissory note.
Sure, thank you, PR. You, of course, in your note, I mean, I'm not going to cover all the possible terms because that'll probably take the whole hour, but some of the ones that I feel I should highlight for you are that, of course, you want to define the events of default under the note in case you ever have to collect it. So, for example, you want to include as terms of default things such as the non-payment of installment, the voluntary or involuntary termination of the FA's employment for any reason or for no reason, the FA's death or total disability, the FA's bankruptcy, the default on other obligations to the firm. And in connection with that, you need to make a decision regarding whether you want to explicitly include obligations to follow the firm's policy manuals, as well as obligations to follow industry regulations and laws.
Yeah, and Sarah, some of the interesting features of default that maybe, and we're going to talk a little bit about them later, but maybe we didn't mention there, non-payment of installments is a tricky one, right? Because it puts you at odds with a current employee. And we're going to discuss that a little bit later. But another one that's tricky and maybe people don't always realize is someone no longer holding the functional title of a financial advisor. That could mean a non-producing manager, but it could also mean, like we at Wells Fargo here have an enterprise, banks, financial institutions, someone transitioning to a role within some other part of our enterprise also.
Absolutely. Or, I mean, at some firms, there are certain minimum production criteria that someone has to meet in order to retain the title of financial advisor. And the person might still continue to work for your organization in some capacity, but they will no longer be financial advisors if they, by title, if they don't meet that minimum criteria. So that's absolutely something that you want to include in terms of default provisions.
Now, Don, as Sarah says, the notes contain any number of remedies at the time of default, but I'm a lawyer, I'm your client, I want my money yesterday. So what can I do to get money in the door quickly? I know I can sue.
One of the things that typically happens is that a lot of these promissory notes will have provisions where the FA, he or she will have agreements with the firm where they've granted a right to the firm to offset part of those claims with assets that they may have at the firm. And so generally you'll see over the years seen different types of agreements that come in where someone have agreed to have a lien on a brokerage account, for instance, that they have with the firm. And so in connection with those, a lot of times you may have a provision that says we can offset amounts you owe to the firm with assets we have in hand. Remember, one of the issues that can come up with that is, would you have the right to offset earned but unpaid commissions or other items that they've had compensation that may be due? And that's an area you'd have to be very, very careful because there are a number of state laws that would come into play. And I know in Texas, we have a Texas Payday Act. And so when you're dealing with earned income, generally those, you need to pay people for the work that they've done. And so most of the firms don't attempt to obtain the or basically compensation that gets paid. But it's very common for most of the broker dealers to have in the account agreements and sometimes in the loan agreements themselves a provision that says we're able to offset or basically apply amounts that you have in the brokerage account towards the debt. I know a few years ago I had a case that involved a financial advisor who had just such a provision, but he had gotten into an issue where one of his clients had named him as a beneficiary under their will. And so this client left the broker $1 million bequest in their will, and he said he didn't know about it until after they died. However, because this was prior to the recent rulings that dealt with the procedures you have to go through if you're going to be a beneficiary in a client's will. And I think we've done some previous seminars in connection with those new rules. But in this particular instance, it predated that. He was basically told you can inherit, but this is a non-family member. You can't do so as an employee. He went out, resigned from the firm, filed a lawsuit, and tried to enjoin the firm from getting the assets that were in the brokerage account. Ultimately, there was an injunction that got entered, but there was an arbitration provision, and ultimately the matter was settled. By way of explanation there, he also, though, was one of those examples of the greedy dog gets no bone. He had what he thought was a bequest from a client for $1 million. He owed the brokerage firm about $850,000, quit his job, but then gets sued by the heirs of the client. They ended up doing away with the bequest. He ended up having to pay us back his loan, and then ultimately he was barred by FINRA for not disclosing an outside business request in connection with all that, so he ended up losing all three. But generally, I think you have to look back at the note provisions themselves, looking to see, can you go in and apply that? And many times there are provisions where you can take those funds that are in the brokerage account. One complicating factor would be if you have accounts that are dealing with 529 accounts, or they're acting in a custodial capacity for a third person, you have to be careful with those. And if it's a joint account with the spouse, generally, I think joint accounts, you may be able to go in and grab those, but more often than not, I see these situations where the financial advisor may be involved in a divorce, and so then you may get into some complicating factors with the spouse in those instances. And again, it's going to be dependent on probably whichever state you're in and the wording of the documents that you've got in your loan agreements.
So yeah, so to summarize, and I get that we're going to treat income and assets a little differently. Obviously, people have to be paid minimum wage for their work. But one of the things that we also have discussed, you and I, in the past is none of these remedies work unless you actually freeze the accounts in question, right?
Yeah, the worst conversation, and part of my career I did spend in-house and then dealing with in-house counsel all along. The worst feeling in the world is when you say, well, we've got this wonderful provision, we're going to be able to offset the amount due with these funds, and then you get a call back from the in-house counsel where they forgot to actually put a freeze on the account. And so the funds all already ran out the door before you can avail yourself of that potential right.
Not naming any names, right?
It's excluding all present people.
Right, exactly. It would never be any client of yours that might be on this call. So even so, now there's this unpaid balance. And Justin, do you have any thoughts on considerations when you're deciding sort of when, how, and where to sue?
Yeah. Well, in almost every promissory note, there's going to be a form selection clause, virtually every one. And that the vast majority of those form selection clauses are going to be require that the parties litigate in FINRA. We have seen some form selection clauses that try to require the parties to litigate in state court. And while we completely understand that there may be advantages and benefits to being in state court, especially in a prom note case, FINRA has actually issued several notices clarifying that such clauses are actually a violation of FINRA rules and could subject the firm to discipline. One of those regulatory notices is 16-25 to take a look at. And in that regulatory notice, it's interesting. FINRA actually provides specific language that they would like in a form selection clause that, there's multiple forms other than FINRA. So they were recommended to be non-exclusive and the following language. This agreement does not prohibit or restrict you from filing an arbitration claim in the FINRA arbitration forum as specified in FINRA rules. And it's just very important to be aware, while you might want to be in state court, you don't want to subject the firm to disciplinary action. And I know Don had more experience with, this specific regulatory notice. So
Yeah, in the past, what happens, and this is not only in the employment context, but in others, you'll have various FINRA rules that come into play, and the courts will try to interpret what these rules mean. And in connection with this particular notice, you had different court of appeals that had differing opinions on whether or not you could waive the arbitration provision and what language could be used. And there were discussions even about the particular language, does it mention arbitration or not? And after the series of those particular Court of Appeals decisions came through, FINRA came out with their notice reminding people that the FINRA rules are not just a suggestion, they require you to operate under them. And so the history behind it is always very interesting. And so there's always, in the courts, as lawyers, we always take great pride in trying to interpret what we're doing. And sometimes we can come up with very creative arguments in the way to describe things. But FINRA can come back through the rulemaking process and again, pull this back and say, there may be a disagreement among the courts on how to interpret it. This is the rule and this is the way we want you to interpret it going forward.
Sarah, you and I now, we've had a few conversations. You've advised me of the FINRA rules. You've convinced me that I don't want to get in trouble with FINRA. So we've chosen to go into FINRA arbitration. Walk me through some of the procedure for how these notes go through the system. Sure.
There is a dedicated FINRA arbitration rule for promissory note proceedings. It is Rule 138.06. This rule applies to arbitrations solely involving a member's claims that an associated person failed to pay money owed on a promissory note. So if you're going to bring a claim against the FA for failure to pay the note and other things, this rule will not apply to you. Under the rule, a sole public arbitrator will be appointed to decide the case if the FA fails to file an answer or brings no counterclaim or third-party claims, or does bring counterclaim or third-party claims, but they're only seeking to recover $100,000 or less. If those criteria are not complied with, then there will be the usual 3-member arbitrator panel, which will include 1 non-public arbitrator. Furthermore, if the associated person does not file an answer, then the discovery procedure will be the same as for simplified arbitrations, which is an expedited production of documents pursuant to a document request. And if also if they do not file an answer, then the case will be decided on the papers. And this rule was passed to address situations in which the FA filed no answer or filed only a minimal counterclaim, and yet you had to go through the entire procedure that you ordinarily would have in a case, which of course delayed matters substantially.
Thanks. I'm wondering when's the last time an FA filed a counterclaim and didn't actually make it $100,000 or more in your experience?
I can't remember that far back.
Okay, right. And that's a good segue to Rima. I always tell my clients that litigation is sort of like that door at the back of the restaurant that kind of swings both ways. And What are some of the things that you see coming back through that door at your clients once they go into arbitration?
Well, employees have all kinds of ways to try to, switch who's on what side of the V, in terms of litigation. I think Justin was going to talk briefly about getting, coordinating statutory employment claims when they're filed in court and in arbitration. If we could go to that for a second, then I'll chime in on what kinds of claims are usually at issue.
Of course, yeah. So FINRA rule, and it's 13803, which is it's a rule that provides the parties with, I guess, several options to either move claims from court to arbitration or move claims from FINRA to court. The rule is very detailed and it's pretty clear, but there's three different scenarios where the rule comes into play. The first is where an associated person will file statutory discrimination claims in court and file non-statutory claims in FINRA. Under the rule, when this occurs, the respondent may compel the claimant to bring the arbitration claims into the same court proceeding. Very quickly, some requirements to keep in mind. You must notify the claimant before the deadline to file an answer, and you must provide a copy of that notice to the FINRA director. And if you do not provide that notice before filing the answer, you waive your right under the rule. The second scenario, similar but slightly different, is when a party has a pending FINRA arbitration against an associated person. For example, a firm is trying to collect on a promissory note, and the respondent then files statutory discrimination claims in court. The claimant, this time in the arbitration, has the option to move the claims in arbitration to court. Similar requirements, you have to give notice to this time the respondent before filing an answer in court, which is slightly different, and you must give a copy of that notice to the FINRA director. And again, if you don't give that notice, you waive your right. The final scenario under the rule is when a party files claims in court that are subject to mandatory arbitration. This is the most common scenario that we see. The rule 13803 specifically states that the defending party may, upon motion, compel the claims to FINRA, at least those claims that are subject to mandatory arbitration. Also, we always like to keep in mind that even if a claim is not subject to mandatory arbitration, such as a statutory employment claim, the parties can consent to FINRA arbitration of those claims. And I know that you probably want a recommendation on where we prefer to be, either FINRA or court. Unfortunately, there's not a clear answer. It's really a case-by-case analysis. So when you're deciding under this rule what to do, we always like to look at several factors. And honestly, we could probably talk about this alone for an hour. So I'm going to be very quick. Some of them are, the cost of litigating in court versus FINRA, or both, if you want to proceed on two tracks. The latter option is obviously the most expensive. Another consideration is how long until a final hearing. In some courts, without naming names, maybe New Jersey District Court, it might be 3 years because of a backlog. FINRA arbitrations typically are scheduled for about 9 months to a year after the initial conference. I think that's going to change because of the COVID backlog, but we'll see. Probably the most important factor for some firms, or for all firms, is the risk of reputational harm. Court filings are public and FINRA filings are private. That's basically it. So it's in this day and age, it's a very big consideration. Another one is if there's grounds for an early dismissal. So if you are in arbitration and you have claims that might be barred by a statute of limitations, or there might be other grounds for a motion to dismiss, moving those claims to court could be a strategy. And then finally is if the parties do consent to having claims, statutory employment discrimination claims in FINRA, an added benefit of that is you will be assigned a qualified employment panel, which is basically a panel of arbitrators with more experience in employment. And it's debatable whether I guess it's a benefit or not, but we always think it's better to have more qualified attorneys on the panel and those with experience in employment specific litigation.
Yeah, one of the factors you didn't mention was whether or not you're being sued in California, but we'll we'll skip over that one, and maybe now we'll come back to you, Rima, on litigation's a two-way street, right?
Absolutely.
And,
Right.
and sometimes it's even, as you mentioned briefly, there's a preemptive strike that a broker's incentivized to take. So walk us through some of the things you've seen with your clients.
Absolutely.
What comes at them on that street?
Of course. So everyone, we've been talking about firms suing for repayment on prom notes, and everyone knows that litigation can go the other direction as well, with an employee or a former employee suing the firm. So these suits, as TR just pointed out, they can be preemptive, where somebody's trying to get out from under that note as a preemptive strike, or they can be reactive. They can come from former employees, which I think is what people typically think of as the norm, or they can come from current employees, and I'll talk about that in just a little bit. If we could go, let's see, the slide. Am I on the right slide? The slide shows some of the kinds of claims that we're talking about from employees. So what is the point of this employee litigation? And that's what it is, it's employment litigation. Our employment law group, virtually every case that we have involving an FA departure also involves prom note litigation. Regardless of how or when the claims present, the goal is usually the same. The person wants to either have the prom note effectively nullified based on some sort of equitable argument typically, or they're trying to set up a set-off. Where the employer ends up owing damages that exceed the prom note debt or get the employee part of the way towards payment. I think, as I said before, people are most familiar with these claims from former employees, of course, because those are the people whose note obligations have already been accelerated and they're due. Most basic, I think, in this regard is a claim of wrongful termination or constructive discharge, where the employee says, "You prevented me from staying. You prevented me from paying off this note, so now you can't hold me responsible for the balance." And the answer, of course, is yes, we can. That's what the agreement you signed says. Everyone on this webinar is likely aware that at-will employment is the law in most places, everywhere but Montana. But FINRA doesn't always honor that. And so some claimants come with these wrongful termination or constructive discharge cases and argue that they should be free from the prom note obligations. Some of them argue that the agreement to arbitrate disputes in FINRA necessarily imports a requirement that the employer have cause for termination. And the practical reality with these cases is that the less compelling the employer's reason for the firing, the more likely it is that a FINRA panel will sympathize with the claimant and come up with some way to offer debt relief. Some of the other causes of action that terminated employees try to use are breach of contract, where various different things can serve as the basis for such a claim. We have some examples of those in the slides. Claims about the forfeiture of unvested, unearned, deferred compensation upon termination are common. Claimants say it's earned, it's mine, and you can't take that away and try to collect on my prom note, because if I stayed, I'd have gotten both the deferred comp and the debt relief over time, but you didn't let me stay. Claimants sometimes sue for defamation, U5 defamation or otherwise, and the claimant can, in that regard, they can either be going after damages, again, with the idea of a set-off in mind, or they can be trying to show bad faith on the part of the employer, again, and shift the balance of the equities in the minds of the arbitrators so that they, lean in favor of some debt relief. Claimants sometimes actually just directly attack the validity of the prom note itself. And I think, Don, you were going to talk to us a little bit about that. That sort of thing.
Don, if I may jump in real quick, just because we're at the halfway part. The first code is a promissory, and I put it in the
And Rima, I didn't mean to jump in and cut you off. Go ahead and finish.
No. I was saying, that sometimes they attack the validity of the note itself, and you're going to talk to us about some of the ways they do that.
Yeah, when looking back on these, one of my favorite all-time responses to a claim we were making in connection with the collection, a lawyer out in Arizona a number of years ago wrote me a letter that says, my client, like many young financial advisors in their position, drives too much car, lives in too much house, and married too much spouse. As a result, they don't have the funds to repay you. And so a lot of times when you get into these types of claims, we have a lot of cases where they do come in and they want to talk about why their different issues have come up, why they aren't able to pay. None of those are legally sufficient defenses to a suit on a promissory note. So most of the time we do see a fraud in the inducement type claim where they promised me I was going to have a certain number of sales assistants or a certain amount of support, or I was going to be in a particular line of business and the firm decided to go in a different direction. And so in those types of instances, you do see an awful lot of claims that come up where they are pointing to, I was somehow defrauded in connection with when I came over. Those types of claims have a lot of problems in asserting those types of defenses most of the time because the promissory note itself and the documents are going to be silent on all those particular terms. And especially in Texas, we have some very good case law on you can't do away with your legal claim to repay the note by citing to different types of parole evidence or other outside factors. But when you're looking at fraud in the inducement, promissory estoppel, negligent misrepresentation type claims can come into play. Generally, breach of contract type claims aren't necessarily going to carry the day. On most of these, and I think TR would probably agree, when we're looking through and deciding how to pursue these claims and whether to do so or not, you're really looking to try to filter out what are the valid claims, what are we likely to get back. So we usually find out on the front end, what were the circumstances behind.
Uh-oh.
I bet that was going to be really good.
Why the person left, so we can, when you look, whether you're at the courthouse, what's that?
You froze for a second.
Sorry, I lost that last part, Sarah, but it's really a shame because that was the most brilliant part of this particular presentation. So
what I figured.
I'm not sure where I came.
Yeah, well, I know what you were talking about, and you and I had spoken about it, and we've all talked about, one of the things I think that advisors and their counsel sometimes wrongly believe is that by throwing everything in the kitchen sink in a complaint or in a claim or counterclaim, they're going to somehow mystify outside counsel and in-house counsel, and we're going to somehow just throw up our hands and say, oh man, this is too much of a mess. And I think what your advice to, not if you were not asked to give advice to brokers, but the advice is, focus on what's actually an issue, because we're well versed in cutting through a lot of the background noise and getting to what may really be going on there. So it doesn't benefit people to just throw in all of these types of claims, wrongful termination, for example, which may not even be a claim under the law, and those sorts of things. But one of the things you said, Don, I think sort of harkens back to what Rima was saying, which is there's a lot of throwing around of accusations. And Rima, you and I spoke about the fact that, Wells Fargo is a huge company, Merrill, UBS, whoever, huge companies, but when someone's saying I was lied to, that's a personal statement. It's
right.
And it has a target, and that target isn't, Uncle Wells Fargo. That the target is someone within our organization. So talk a little bit about that sort of personal connection to these lawsuits.
Absolutely. And that's always the case in employment cases anyway, right? They're emotional cases. They involve people on both sides. Claimants counsel often tries to portray the respondent or the defendant as a big bad corporation, but the big bad corporation is made up of people, and those people have sometimes invested a great deal of time with this individual employee, and they feel wounded by the fact that this person is suing the firm and calling out their, sometimes their conduct as problematic. So it is definitely a huge dynamic in employment matters, and it's especially so with current employees when current employees sue. And I bet some of our audience members are wondering, how is it that promissory notes come into play in lawsuits brought by current employees? But claims that are meant to undermine the enforceability of prom notes can come from current employees. And typically this is somebody who wants to leave, but is stuck because he or she can't pay that back, the prom note debt, because as Don pointed out, they spent it. It's long gone. So, I wanted to point out, and as we talked about TR, it's really interesting to think about that, like so many things related to FA compensation, we talked about deferred compensation a few moments ago. Upfront loans secured by a promissory note are intended as a retention tool, right? The idea is to keep the financial advisor in the seat by promising them that you will tick down the debt that they owe over time. But the flip side of that is that down the road, it may be that the firm would like to exit this person, or that the person would love to be free to leave, but everyone feels a little stuck because we have this prom note debt on the books, and it's spent, the money's spent. So what employees sometimes do is they bring claims, that current employees bring claims that are not directly based on the prom note, claims for other things, regular employment law claims, the things we see every day, claims for discrimination, harassment, retaliation, unpaid bonus, whatever the case may be. And then as part of their requested relief, especially if we're in FINRA, they throw in a request for something like, declaratory judgment that the promissory note is unenforceable or invalid. And sometimes this loosey-goosey kind of pleading will fly in FINRA. And that's why the forum selection considerations Justin was talking about earlier are so important in employment cases. Practically speaking, an employment claim by a current employee with a prom note debt is most likely aimed at forcing a negotiated exit, on the assumption that as part of those negotiations, the prom note debt will end up on the table and maybe we can reach a deal that allows the person to leave. Another thing we discussed in preparing for this webinar, TR, is that litigating with a current employee can be a minefield. It's very, very tricky. You have a current employee suing, so now everyday workplace interactions are fraught. There's a claim of retaliation lurking around every corner, and it just raises the stakes. So sometimes a settlement that exits the employee can offer relief for everyone, and some employers conclude that that's worth some level of prom note forgiveness, but it's not always that easy. Prom note forgiveness hits the bottom line of one or another business units in the firm, right? And the business unit in the firm whose bottom line it hits may or may not be comprised of the same people who need relief from this person. So those people are weighing different things. Also, firms are very, very wary of, handing out prom note forgiveness because precedent is very important to consider. So many FAs are sitting there with prom note debt, and if they get the idea that the firm, if you make enough noise, throw enough claims out there, that the firm will forgive it, that can be a real problem. And then, as you mentioned before, emotional factors play a huge role in every employment law matter, and prom note cases are no different. Can the decision makers stomach letting this person off the hook? Well, that can depend. I mean, has the person been milking the system for a long time? Have they been a pain in the neck? Is there conduct at issue that people feel strongly just shouldn't be rewarded? So, the cases get emotional. And the short of it is that for every claim that an employer may have to enforce a promissory note, the employee or former employee can come up with 3 or 4 claims of their own to try to undermine that promissory note or create a set-off situation.
No, that's absolutely true. The precedent thing is huge. I know all, the in-house people I speak with, it's something that's always on our minds because we have to live with the consequences of whatever the resolution of an individual piece of litigation is. We have to live with those consequences for a long time.
For sure.
And obviously there's, how 15, 18,000 brokers at Wells Fargo. And so that's a long time to live with. I know you let so-and-so out of this note.
But how do they know, TR? Isn't there usually a confidentiality provision?
No, right. People always live up to their obligations under a confidentiality agreement. I've always found that to be the case.
Just like they lived up to their obligations under the promissory note.
Exactly.
That's absolutely right. So as we are talking about resolution of these matters, and sometimes, as Rima said, the promissory note isn't really an issue, but it is the 800-pound gorilla in the room, right? But for this note, the person would walk. And sometimes the current manager would let them walk because the current manager isn't the person who hired him in the first place. But Sarah, can you talk us through some of these considerations that we have when we're trying to negotiate an exit?
Yes, of course. So now at this point, you've managed to persuade your client that it might be wise to see if things can be compromised and the litigation can be resolved. And it's time to think about settlement provisions, in addition to, of course, the amount, which is the biggest concern generally for both sides. But there are other concerns as well. For example, one question is, as part of the settlement with the FA, can the firm agree not to object to expungement? If the person was terminated for X, Y, or Z reasons, this of course has to be reported under U5s. A lot of FAs, as part of a settlement of a prom note debt, they want to ask for the arbitrators for expungement, and they want the firm to agree not to object to that expungement. And the firm can't always, even though it's a non-monetary consideration, it's not a consideration that the firm should take lightly, because there is a tension between a concern for the integrity of the reporting process and how the regulators are going to view an agreement not to object to an expungement proceeding or a regular granting of expungements of reporting on U5s. And so it's not an unimportant consideration.
Yeah,
if you are considering agreeing to that as part of a settlement, I think that part of what you have to think about is that you are required to report allegations against an FA. Allegations may or may not be true. It's your obligation to report them accurately, but that does not mean that you found out that they're accurate. So that type of thinking might mitigate some of your concerns regarding the integrity of the reporting process and regulatory concerns. But I've seen this go different ways among different firms. Most firms I've worked with will not agree to not object to expungement because they're more concerned about the integrity of the reporting process and the regulatory concerns. But there are firms who will agree that there should be no objection to a request by the FA for an expungement.
Could I interject here just real quick, TR?
Sure. And I think
one of the where I've usually seen these issues come up is that, firms all take very seriously their obligations to report and report accurately. And because our U4 system is based on bare allegations and not the actual outcome or the validity of those underlying complaints, you can have things that come in, and sometimes financial advisors, I don't think, understand we don't have a choice on whether something gets reported or not. So we have to look at the allegations and report based on those allegations. It's unfortunately, we don't have an idiot box on the U4 that says this is not reportable because the person who made it is an idiot and it has no validity. But on the expungement context, there can be an absolute justification for saying, yes, this had to be initially reported. And there could be an absolute right to say, yes, but the underlying complaints are false, or I didn't commit the sales practice violation, or those sorts of things. So in those instances, the expungement would be proper, and you can go ahead and look at those. Sometimes where that could come up is there could be an internal review, for instance, and there's a question at the time that this person left, they were under internal review. There's no question. You can't agree that that didn't happen and have those types of things removed. But if it's surrounding a customer complaint or a resolution of something else, I think firms, a number of them can agree on that part. There could be other reasons, though, with the expungement of why they may not be able to agree, and you have to look at those in a case by case.
Could I add something there?
Another issue, I'm sorry?
I wanted to just add one thing, if I could, on the question of expungement and firms agreeing to it or not.
Please.
Yeah, and sometimes there are cases where the firm does not feel terribly strongly about whether the language is expunged off of the U5. They believe that when they made the report, it was true, and they don't want to come off of that because, they're not now saying it wasn't true, but it's not a big deal, and they don't care deeply about what this departed FA's U5 says. And in those instances, they can't agree to just expunge it because it was true when they made the statement. But what they will do instead, knowing that FINRA panels sometimes are lenient in expungement matters, is they'll agree to some sort of abbreviated proceeding. We're going to oppose it. We really are. It's not a joke. We're going to oppose it. But, we'll say, you can have one witness, we'll have one witness, you can have two, 1 hour, we'll have 1 hour. And you agree to a narrow proceeding that you think may result in expungement, but you're not that worried about it, but you do oppose it.
Yeah.
Yes, that would be a compromise position between the two situations. Some firms, however, in my experience, they will simply agree not to object to the proceeding. They will not participate. And there's nothing in the FINRA rules that requires the firm or that bars the firm from doing that, as it would in a customer case. In an employment case, that would be different.
Mm-hmm.
Another provision that I think you want to have, and an issue that I think you may very well have in connection with your settlement, is a provision reciting that you are not giving tax advice to the financial advisor, and that the forgiveness of any part of a note as part of the settlement is going to be reported to the tax authorities as income to the financial advisor, and that he will be responsible for any tax consequences associated with the forgiveness. For some reason, when it comes time for settlement, the financial advisor and his counsel are in shock that they've received money that they were supposed to repay, that they're not going to repay, at least partially, and that somehow that's going to be income to them on which they have to pay taxes. But this is one of these things that comes up, to which the answer has to be, those are the tax laws. We have to follow the tax laws. You have to follow the tax laws, and there's nothing we can do other than to report the forgiveness as income.
Yeah. And Sarah, on that point, I mean, that's a great point. I mean, people have to realize that the lump sum, the bonuses are meant to be paid out over time, right? And so the lump sum sort of throws the tax reporting out of whack. If the bonus is paid out periodically, the taxes would be deducted. But when the bonus comes out in a lump sum, then those taxes still are only being deducted periodically. And at the end of the day, there's a big balloon payment due Uncle Sam. And you can't get around that because you had the money and it's in your pocket. And it can be a material impediment to settlement in some of these cases, much like, whether or not you defend expungement. But I don't think, in a lot of these situations, there's no choice on tax reporting. And there is, I guess, maybe some choice on expungement. Although I will tell you, in my experience, generally firms defend their own allegations of misconduct and are sort of more neutral on other allegations of misconduct.
That is correct. And then finally, in connection with your release, if you're going to settle, you of course want a release that will prevent any further litigation over anything that could conceivably have to do with the FA in question on the firm. So you want to make sure that that you include the correct language in your release so that asserted and unasserted statutory employment claims are released as part of the general release. I mean, an example is, the usual, you have 20 days, 21 days to decide whether you're going to sign, you have 7 days to revoke. So you want to make sure that you get all of these statutory employment provisions dealt with in your release, because otherwise the law is probably going to be that any such statutory employment claims are not released. And now here you took less money, you forgave a part of the note, and somebody's going to bring a claim against you for example, discrimination on the basis of age, and there's nothing you can do about it because your release did not meet the requirements for release of age discrimination claims. And I also see that we have a question here that I don't know if it really fits in with anything. So let me just address this now. Somebody wants a discussion of the FINRA arbitration provision that discusses set-offs in awards. I think this person is talking about Rule 12904J, which basically says that if an award is rendered in which payments are required to one another, for example, you, FA, will be paying your $500,000 that you owe to the firm. You, firm, did something wrong in dealing with this person, and you will be paying $300,000 to them as compensatory damages. And obviously the person owes $200,000 more to the firm than the firm owes to them. Well, this rule was passed to eliminate the argument, the rather annoying argument that was being made in many cases, in which people said, well, I'm going to pay you my $500,000, but first you have to pay me the $300,000 that you owe me. And by the way, I don't have the $500,000 to pay you, but you have the $300,000 to pay me, and you have an obligation under FINRA rules to pay awards within 30 days of when they are rendered. So this was addressed with this rule, whether or not the arbitrator said in the award, competing awards to the parties are set off against each other, and the net number is due from somebody to somebody. And it's not possible to require that people pay both sides in order to get full payment done.
Yeah, and thanks, Sarah. That's a good segue to sort of maybe sum up and end on with Don. I mean, I've got this award in hand. I've paid my outside counsel, but I still don't have a check from my deadbeat former employee. What do I do?
Well, first I pick up the phone and call Sarah and say help. But generally in collecting an award against the FAs, you typically go to FINRA, and FINRA has the rule 13904 that says you have to satisfy a FINRA award within 30 days after it's issued. And what happens is you should notify FINRA immediately, although they get copies of the awards through the arbitration process. And then FINRA will send out a letter to the firm and to the respondent, if you're in the industry, asking if the awards have been satisfied. If they're not satisfied after 30 days, FINRA will send out a letter, and there's a FINRA rule 9554 dealing with an expedited disciplinary provision that says if you don't pay the award within 30 days, you're subject to almost immediate revocation of your license. And that sounds like a very powerful tool in terms of making sure we get awards paid. On the defenses, though, if you don't pay an award, are usually you have to show that when you get this letter from FINRA, if it hasn't been satisfied in 30 days or they don't have a record of it, you have to show them that the award has been paid, or that you've reached a settlement with respect to the payment, or you filed some type of appeal or continued action where it's still under dispute in the courts, or you filed bankruptcy. Another defense to that, though, is a bona fide inability to pay. And FINRA recently, back in I think 2010, changed that inability to pay provision on customer cases to say that's not a defense. In the intra-company disputes, though, that still is a defense. And most of that comes from a series of SEC releases in dealing with disciplinary decisions that you have to take into consideration the inability of the financial advisor to pay. So long and short, there is potential disciplinary action by FINRA. Financial advisors, if they can establish an inability to pay, might be able to get around the disciplinary side. But that just covers the FINRA side of the equation. Once you do get that award, then you can go into court and reduce that FINRA award to a judgment. And in most of those instances, you file a state court lawsuit, you file an application to, in effect, finalize the award. And what we generally do is there's certain timelines for people to file appeals in connection with an arbitration award. If the claimant is going to, or whoever loses the case is going to appeal, they have to do so within a certain timeline. And if they don't do that, then the appeal at that point is they basically missed their appeal point. Many of your confirmations of the awards are then filed after that time for filing the appeal has already passed. You can file that in the state court, you get it reduced to a judgment, and then at that point, you're back to doing the normal arguments that you would in just about any case of going and then trying to collect on that. I see I'm getting down to 12:27 and I've already talked too much, TR. I'll pass it back to you. We can just your standard state court collection proceedings go into place once you reduce it to an award.
Yeah, and thanks, Don. And I did want to leave a couple minutes for questions, but just to conclude, just to say, I think understanding, from a client perspective, it's important to know that your client's gonna view all of these promissory notes that are out there as a portfolio of assets. And those assets are either being collected on timely and producing, or they're going to need to be in some form of litigation, some part of the litigation posture, in order for it to satisfy internal accounting requirements, in order for it to be seen as a productive asset. And so, I caution everyone who's outside counsel, I caution our opponents to think that we're just going to cut breaks left and right on notes, because they are assets. And those assets are meant to produce income to the firm as well, and so just to be sensitive to that fact. This is money. It's real money, to not just to the broker, but also to the organization. I don't know. I can't tell on my screen whether we have any questions or whether, Justin, we should give out the last code.
Yeah, exactly. You read my mind. The second code is note. I think you could have expected that, but so first code promissory, second code note.
Does anyone have their finger on the pulse of whether or not there are any questions? I can't tell from where I am.
TR, I only see one question that we didn't answer. One question we answered. The other question was, and I'm afraid I don't understand the question. So if any of you understand it, please try to provide an answer. The question is, can the firm recognize the commission owed to reduce debt forgiveness?
So the question was, can we enter into a negotiation to alter the terms of a note?
I think what the question might be asking is, if the former employee is claiming commissions are owed, right, and so that's a debt coming his or her way, can the firm recognize that and just sort of by itself, without an order from FINRA or something, just offset that? And I think it goes back to some of the considerations we were talking about earlier. These are earnings. This is income. If you owe somebody commissions, you better be careful not to pay about not paying them unless you have a comprehensive. So you can certainly do it in the context of a settlement agreement, right? And you get releases every which way to Sunday. But absent a settlement agreement, I think our collective advice would be very careful about just applying commissions owed to a prom note. You have, Don
Very careful.
Yes, Don pointed us to the Texas law. We know in Illinois, there's the Wage Payment and Collection Act. Most places really put a hard bubble around people's pay and say, just stay away from that. So I think the answer is yes, you can do it in connection with a settlement. Don't do it just on your own.
Well, there's still maybe income tax implications, even if you reach an agreement, because I think it's probably an attempt to try to get around that. But I see we've reached 12:30, TR.
Yeah, right. And the only thing I would add to that is don't breach a contract yourself that you're trying to collect on. Right? It's always a bad place to be. So maybe on that note, I will thank you all, thank the panel, and thank everyone in attendance for making this a productive CLE. Thank you. Obviously, if anyone has any questions going forward, I believe all the participants gave their email addresses, so you can feel free to engage in this discussion going forward. Thank you, and have a great day.
Thank you.
Bye, everyone.
Bye.